Practical Insights from Legal Linguists, which is very generously hosted this evening by the Indigenous Languages Action Forum. My name is Sanja Bornman. I am a senior attorney and a gender law and policy specialist consulting in the private and public interest law sectors here in South Africa. And I have the distinct honor of facilitating tonight's program and the very exciting panel discussion coming up with three of the editors who curated, refined, and pulled Courtroom Discourse together. The panel discussion is going to be followed by some questions from the floor, so be sure to note yours down and have them ready for the panel during Q&A. I want to extend a special welcome to all of the contributing authors who were able to join us tonight. Congratulations to all of you for the achievement that is this fascinating publication, and thank you for making the time to be with us. We look forward to also hearing your voices in the engagement this evening. Before I introduce you to tonight's panelists, we are very fortunate to be joined by Professor Mantua Motinyane. Professor Motinyane is the Deputy Dean of Learning and Teaching in the Arts and Humanities Faculty at the University of Cape Town, where her primary area of research is psycholinguistics, particularly how children produce and comprehend speech. In between publishing, she is involved in a number of high-profile international and interdisciplinary projects, including a European Research Council-funded project on child languages as a mirror of the mind, and a Say It Labs project that uses AI-powered games as an intervention tool for stuttering. When you order your copy of Courtroom Discourse, you will see her very thoughtful and instructive blurb for the book on the back. And I would like to invite her now to introduce Courtroom Discourse and to say a few words. Thank you very much for joining us, Prof. The floor is yours.
Thank you very much for the beautiful introduction. I think just to start off, it's quite an honor for me to be part of this wonderful book launch. I've seen from the first volume up to now. It's just that I haven't had time to make my contributions. One of the areas that I focus on is critical discourse analysis, and I know that is used a lot within courtroom discourse as well. So without wasting any much time, for those who haven't seen the book, I'm going to start off by telling you what I found when I was asked to provide a blurb for the book. So the Courtroom Discourse Practical Insights from Legal Linguists is a 6th volume in the studies of the forensic and legal linguistics in Africa and beyond series. It's a groundbreaking collection which explores the critical role of language in achieving justice, especially in a multilingual and multicultural country like South Africa and Africa in general. The book is divided into 4 parts, and I'm not going to go into those because the authors are going to contribute to that. But what I want to highlight is that the chapters in this series offer practical insights into how challenges that are faced by court interpreters and the legislation. So if you ask me, why is this book special? Why should you buy it? I think this is a selling point. The selling point of this book is that in the South African context, it speaks directly to the country's constitutional commitment to multilingualism, access to justice, and transformation of legal systems, even though that has been lacking in terms of linguistic aspects. So as South Africans, we continue to grapple with deep inequalities in the injustice system, where English and to a certain extent Afrikaans often dominate despite the 12 official languages, and where many people experience barriers in courts and police stations because their voices are not adequately heard or accurately represented. So these issues are addressed in this volume, and that's why I think every one of you should get it. So if you are a linguist, a legal practitioner, an interpreter, a policymaker seeking to better understand and improve linguistic practices in your legal settings, this is the book for you. In a nutshell, as I close off, the volume really responds to the South African urgent need to make justice linguistically accessible by exposing how language practices in courts, especially police stations and legal education, impact fairness and equality. So by foregrounding indigenous African languages in this volume and courtroom interpreting, the book provides a practical and research-based insights into dismantling the systematic barriers, and it advances the constitutional vision of multilingual justice. I will rest there. Thank you very much, Chair.
Thank you very much, Prof, for kicking us off on such a high note. And it is now my pleasure to introduce you to tonight's panelist. 3 of the editors of Courtroom Discourse are with us tonight. And I will start with Dr. Zakira Docrat, who is a forensic and legal linguist, an author, and a researcher. She is a postdoctoral research fellow under the auspices of the Research Chair in Forensic Linguistics and Multilingualism at the University of the Western Cape. She has published very widely national, in international and national journals and books, and her research has been referred to and referenced in both South African court judgments and in the pleadings of a language rights case in the United Nations Human Rights Committee. She recently gave expert testimony in a high-profile South African Judicial Conduct Tribunal, the first of its kind, and she's no stranger to the national media. She has received a number of prestigious awards in recognition of her work, and she holds several leadership positions in the international legal linguistics community, including the chair of the Indigenous Languages Action Forum. Welcome, Zakira.
Thank you, Sanja.
We also have with us Dr. Annelies de Vries, who is a distinguished language planner, academic, and forensic linguist, currently serving as the CEO of the South African Academy of Science and Arts. She specializes in multilingualism, in legal practice, language policy, and legislative language transformation, and has served as a lecturer, researcher, and language planning specialist. Her research focuses on the impact of language as access to justice, legislation, and jurisprudence, and she has significantly contributed to policy development and the promotion of multilingualism in South Africa. She is the vice chair of the African Association of Forensic and Legal Linguistics and serves as a board member of the Virtual Institute for Afrikaans. She's widely published, and she has also been an expert witness in legal cases, and she is an advocate for language as a tool for justice and inclusive social development. Welcome, Annelies.
Thank you, Sanja.
Then we have with us Professor Russell Kaschula, who is the head of the Department of African Language Studies at the University of the Western Cape. He holds the institutional chair in forensic linguistics and multilingualism. He has published prolifically in the field of applied legal studies, including in forensic linguistics, intercultural studies, education, and multilingualism more generally. He acts as an international advisor to the Journal of Semiotics and Law, as well as a number of other journals, and has taught at no less than 5 South African universities and a liberal arts college in the US. When he's not writing, Russell is hard at work nurturing the next generation of scholars and experts. He has supervised 36 MA students and 35 PhD students to completion, and has been a postgraduate examiner for many universities, both in South Africa and abroad. Welcome, Russell.
Hi, Sanja. Thank you very much for those kind words and greetings to everyone in the forum. Siyabulisa kuni nonke. Thank you.
All right, what a distinguished panel. Let's get started on some questions. Russell, I'd like to start with you, and particularly looking at part one of Courtroom Discourse, which deals with the language of complainants and witnesses in particular. How do you think forensic and legal linguistics can assist with combating crime in South Africa, particularly if we think about vulnerable groups like women and the disabled?
It's a very interesting question, Sanja, because I think in the first chapter in this book, I think it's a very important chapter. It's a chapter that's written by Tasnima Nordin and Fiona van Wyk, and it deals with children basically in our court system that have been abused, and the kind of language and cultural factors that come into play, and how people who commit these crimes, or normally older people against these children, get away with it because the language that is used is kind of quite obscure and can be dialectal as well. In this particular case, I think they're talking about a courtroom sort of in the Malmesbury area where a certain dialect of Afrikaans is used. And if the interpreter doesn't know that dialect properly, it has certain ramifications, for the way in which the evidence is led. So I think, every crime, if you think about it, has a linguistic foundation, because all crime is kind of committed through language, whether we're talking about hate speech or whether we're talking about sexual violence or violence against women. It's often it emanates from a linguistic crime, if I can put it like that, or a linguistic foundation. So I think it's important for all of us who are involved in the legal system to be conscientized accordingly when it comes to issues of language and culture in a multilingual, multicultural society like South Africa, or anywhere in the world for that matter. If one compares the American scenario with South Africa, which I've just recently done with colleagues in America, you'll find that the linguistic prejudice against people of color in America is no different to the kinds of linguistic prejudices that we experience in South Africa. And they can either be positive or negative. And in that way, a complainant or a witness is either positively or negatively portrayed in a court. So there's so many facets to understanding the complexities of inter and cross-culturalism in courts. And I do think it should form part of the legal curriculum, and that all people who are involved in the legal fraternity, whether you're a judge or whether you're a defense lawyer or a prosecutor, you should be properly trained, as also all interpreters in the country as well. And that's where forensic linguistics and legal linguists come into play and can play a very important role as well. If I can just mention as well, I think Ms. Raselab is also in this gathering, but her chapter that she wrote on the Witchcraft Act, I think of 1957, is another interesting example, because we also depict cultures in a certain stereotypic way, which is almost anachronistic in a way. And in fact, that particular act probably is anachronistic. I think she's done a good job of highlighting the complexities involved. And one can go on, because even if we take, I don't know how much time I've got, but if I can just give one more example and then come to
Please do.
Annelies and Karin Britz's paper, because it revolves around the term polisimannetjie that a teacher used, and it was interpreted as a, as maybe referring to let me just get the right word, police monkey, in
Oh.
English. And that could be seen as very pejorative, for example, in the same way as kill the farmer, kill the boer, the Malema speech, and all the issues around hate speech and how we interpret language in a court, I think is a very tricky situation in the South African context where our history is so marred by racism and the way in which language is used in a pejorative way. So, yeah, I think section one is really interesting, and Prof. Madonsela also looks at the notion of deception, for example, and whether it can be considered a catalytic agent of lies, and whether certain lies are more lies than other lies, and where does the deception lie in the lie, So it's. I think, you know what? I don't think you can be a good lawyer in South Africa. I don't think you can be a good citizen in Africa if you're not well versed in multilingualism and issues around multiculturalism, because in essence, the way to understand each other is through mindfulness. And I don't think there's often that mindfulness in courts of law. And by mindfulness, I bring in that term specifically because I don't think you have to speak all the languages of Africa or and be steeped in the cultures. But at least, even if you're monolingual, you can teach yourself a certain mindfulness which allows you to enter the space of others without stereotypical bodies or viewpoints. So yeah, I think let me leave it there for now, Sanya.
Thanks,
If
Russell.
there's any
I
questions, I
really,
think.
your comments about how closely related speech and crime are really resonate for me. I think especially when it comes to hate speech, it's so often that the speech precedes the crime. And speaking as an attorney, I certainly never received any kind of sensitization or training around multilingualism, and it's a real shame, as you indicate. I agree with you that it should be part of the curriculum. So, Kira, I'd like to come to you. Part two of the book is about courtroom discourse and legal education. So, the relationship between legal education and legal practice is really becoming more and more important, where lawyers and judges are unable to really formulate their thoughts in English only. What would you say is the solution to that in South Africa?
I think, for me, Sonia, just building on what Russell's also said, is the whole thing revolves around the language of record policy in South Africa. And, when we moved from English and Afrikaans to English only, it was celebrated. And I can't understand how a monolingual policy was celebrated on the basis of transformation. And, for me, when we talk about transformation, we talk about inclusive change. And again, I think at the beginning of this, we were talking, or Prof. Mortignana mentioned the constitutional ideals and those provisions. And we've kind of strayed from that with this policy. And the reason why I bring up the policy is because everything that we've been talking about and this entire book for me, in fact, the entire series, revolves around this policy. And it's quite sad to see the power of one policy, but the way we teach at our universities and how we produce our LLB graduates, even just our general students from various other disciplines, we produce monolingual students. And it feeds into the workplace and into the court system. So as you suggest, I mean, you didn't have any multilingualism sensitivity training or anything like that. So when we, in effect, removed the language requirements in the old apartheid legislation and moved into democracy, we never included the African languages. We never did that. And for me, the policies, in a way, speak past the Constitution, in complete opposition of the Constitution. So what we have now is these monolingual LLB graduates feeding the system. So we cannot expect to say, look, our judges need to be multilingual, or they need to be bilingual for that fact. How do we expect that to happen if we're teaching in English only? But I think, that there's great strides being taken. And if we look specifically at case studies, if we look at what academia is doing, I know Karen Brits is on this platform, Natasha Fenter as well, who are all contributing authors, Annalise as well. And I think what we are doing as well at UWC, teaching forensic linguistics, offering it as a course module. And if we look at section 2, I was just looking, while Russell was talking, and if we look specifically just beyond South Africa and the challenges on the African continent, which the book also brings to the fore, specifically looking at countries like Malawi and so forth, and the parallels we can draw with them as well. But also the fact that there's this pushback, Sanya, from LLB graduates themselves saying, why must I learn an indigenous language if I'm not going to be using it? So I think it's about who you see yourself as. And for me, you're a lawyer, so maybe you'll agree or disagree with me. But I mean, access to justice is at the core. And I think, language is at the core of that. It's about making a difference to people's lives. And I think the mere fact of being able to communicate with somebody breaks down that barrier. And one of the chapters as well in this section is contributed by Nomfundo Mali. And she looks specifically at the Meiwa case. And it's actually her PhD research, which is very interesting because we know in the first instance, I mean, this case we know is so long and protracted, but when we saw how Tefo engaged with the judge and how he was kind of shut down because of that language of record policy, and told that he needs to address the court in English, even though he fumbled and he couldn't find the exact words. So again, it speaks to this unfairness that is created by this policy. I also think that it's placing such a lot of strain on the interpreters. And this is why I say that everything revolves around the policy, because when Russell was talking about the court intermediaries and the research that was produced in part 1 of the book, it also mentions the language of record policy, because the intermediaries themselves are saying, and I think some of them are on the platform this evening, as part of that research saying, look, we've got to rely on an interpreter now as well. So, we're conversing directly with the child where we share that mutual language. But that evidence is, in effect, again, being watered down because the interpreter is interpreting it for court and for the record. So, I mean, what is being reflected on the record is sometimes not an accurate representation of what has been made orally. And I think the focus, many of the case studies coming out in the book are popular cases. But in other instances, there are chapters that deal with cases from the lower courts. And that's fantastic to see, because I think the relationship that we draw between language and law, we always focus on the superior courts and the more popular cases in the media. So, these chapter contributions, and I'm not going to pick out one specifically, I think throughout the book, make reference to various cases in the lower courts and the impact that the language of record has on it. But just to show and go back to your question, I think I completely didn't answer it. But to go back to what you were asking, I mean, there's a direct linkage for me between the language of record policy and a monolingual or a multilingual judicial officer or legal practitioner. So we are actually hindering our legal practitioners and judicial officers from using their languages in court, specifically because of a policy, which for me is absolutely bizarre.
Yes, I agree with you. I mean, I think especially in terms of the lower courts, that is where the majority of people come face to face with the justice system. So we should be paying a lot more attention to what's happening there. And I wonder, speaking about judges, whether this should be something that gets explored by the Judicial Services Commission when they interview candidates for not only positions in the Constitutional Court and the Supreme Court, but all high courts really, and similarly with the Magistrates Commission.
I think
Before,
yeah, because
yes.
it also goes down to race, because I mean, you're talking about the JSC and the questions and whether then we're associating language with race, and we see that coming out quite a lot within this book and the research. But I think it's about saying, look, you're qualified, and when we look at that specific provision in section 174 of the Constitution, which talks about a suitably qualified person to be sitting on the bench. I mean, language has to be part of that process. It goes beyond race. I think, being able to say you're proficient in a language other than English is a positive attribute.
I completely agree. Russell, before I speak to Annalise about chapter 4, part 4, I just want to briefly ask you about part 3, which is about court interpreting and police statement taking. This is something that I'm quite interested in, the idea of police statement taking as really the first step where a docket begins. And if that process is not successful, or if that process is hindered, you are sitting with a situation where a prosecutor is going to look at that docket and think it's not worth pursuing. So some of the chapters in section 3 explore some of the linguistic challenges that are faced by court interpreters during their work. What do you think some of those challenges are, and what is their effect on court proceedings?
So I think it's a tricky area that I remember I had a student who did his master's on taking sworn statements and then back translating them. And the difference in the back translations was so varied to what was presented. So I just think that I think the skills are not there within the police force because, first of all, police persons are not trained linguistically at all to take these sworn statements or to kind of, and the interpreters themselves, I think, lack a good level of training. I'm generalizing because we have some very, very good interpreters. And I think that's brought out in the section as well and elsewhere. But a lot of our interpreters, I mean, you need a grade 12 and you get like a 3-month immersion course, and then you kind of left to yourself. You've got to fend for yourself out there in the courts.
Wow.
And we can see interpreters battling in all the cases, Jocelyn Smith case, the Meiwa case, the Omotosho case, all of our cases, the Van Breda case. There's so many that one can see into where interpreters are kind of deficient or lacking. And so the training, I think, and the inaccurate translation does not work for justice and SDG 16, that sustainable goal where we need to create a sense of justice in the world and where forensic linguistics really fits in. So if the interpreting is bad and the training of the police people who take the statements are bad, which are then what are put through into the court scenario and can then be easily discredited, by the legal fraternity, and the case then fails, I think does not create a sense of social justice at all for the complainant. And that's often very sad, especially in rape cases and so on, where the initial statements are given in a home language, or the interpreters interpreting from isiXhosa or isiZulu into English and so on. And then the culture-specific nuances as well, I think, are often not taken into account within the interpreting process, or people are unable to deal with them. And they can often be dialectal as well, as I've already said, or there's variations, even within specific communities. So just because you're an isiXhosa speaking interpreter doesn't necessarily mean that you would be able to understand the urban varieties of isiXhosa that are spoken in, say, Khayelitsha, So there's so many different things. So there's a lack of training, I think, in these cross-cultural elements. I think we also need to provide language resources for court interpreters that we possibly are not providing. I think there is a manual now that they get. But we had long discussions with the justice cluster last year. Was it last year or year before? And it was all looking very good. We were going to be working on a system where we could upscale the court interpreters through programs that we'd offer at UWC, but unfortunately that came to naught. So I think we're still sort of with the system that exists at present, which is wholly inefficient, and I don't think augurs well for the justice system. I remember another case that Zakira and I worked on, the Sikafungana case, where a person who was deaf was raped, and there was absolutely no interpreting for her available as a deaf person. And that rapist actually got off because the evidence was only collected a day or two later, and he was convicted of housebreaking, but not of the actual rape and so on. So, I think there's a lot of injustices that happen in the system because we don't have this interpretation, and even the police people taking down accurate or conveying accurate statements that will enhance the delivery of justice. So that would be my comment on that one. I know it's quite a controversial area because we have brilliant court interpreters, but if you speak to them, they've got there on their own. They really have been dropped in the deep end, and they've become brilliant interpreters by the time they're 40 or 50, without necessarily any solid support from the system. So I think we need to think carefully about how we can upscale and support the interpreters and the police people who are involved in these court cases where interpretation takes place. Yeah.
No, absolutely. I remember watching, of course, the recent Judicial Conduct Tribunal around Judge Mbenenge and the allegations there. And to me, the interpretation seemed certainly a little bit dry, a little bit stilted, and I think a lot of the sort of the qualitative elements of the evidence that was being given was lost in translation. It felt more like a translating exercise than an interpreting exercise.
Yeah.
And I think absolutely it does feel to me like, as you said, there's very little support, and there's a bit of a supply and demand problem as well. Lots of legislation talks about the need for interpreters, but where are all these interpreters going to come from is, of course, the
And
question.
who's training them? Why are we not training them? And I think it just
Absolutely.
breaks the trust in the whole legal system, because imagine you're a complainant and then the person gets off, like I'm just
Yes.
thinking about Cheryl Zondi actually as I'm sitting here, although I mean she spoke brilliant English and she was able to speak back to Advocate Doberman in a way that she wouldn't have been able to do if she was not a good speaker of English, but imagine that Omotosho still got off at the end because of bad prosecuting. And how do you feel after that when you've been violated and the 60 odd charges? I think you feel completely distrustful of the system. I mean, I just don't, I wouldn't even imagine how you actually feel as a person who's either a complainant or a witness where things like that happen. And they're not just based on linguistics. I mean, I remember also if, issues around terminology like sexual parts and so on, it's easy to say penis or vagina or whatever in English, but it's not the same. It's not so easy to say that in an African language, and for a person, even if they're good at English, to be able to have to answer questions about levels of penetration and so on, I just think shows the level of cultural disrespect and misunderstanding, if you like, that exists in courtroom practices. But I think obviously interpreters and police people also have to face this on a daily basis. But I just don't think we've applied our minds properly to that area of interpreting and the whole cultural and intercultural and cross-cultural kind of nuances that should come into play and how we should deal with these issues. And yeah, maybe I know Zakira and Annalise might have something to say about using AI as well, to improve the situation, but perhaps that's a debate for another day, and I don't think it comes as part of this book. But I just want to also say what Zakira picked up on in her contribution as well is the practical nature of the book, because that sets it apart from any
Yes.
other of the forensic linguistic textbooks that we've put together. It gives you practical insights, and there's a lot of cases and practical aspects to how the forensic world actually works. And I think that's another important aspect of the book itself. Thanks,
Thank you
Sonia.
very much, Russell. Annalise, part 4 of the book is about customary law, legal language policies, and legislation. And in his initial intervention, Russell spoke about the case around the Witchcraft Suppression Act. And perhaps you can talk to us a little bit about how that matter really revealed how meaning can get lost in translation. In other words, how does that case highlight the risks of misinterpretation in these multilingual court settings? And what kind of reforms do we need to mitigate that kind of risk of injustice?
Thank you, Sanja. So, just to bring the whole part in context, there's as you said, it's been on customary law, legal language policies, and legislation, and as Russell just said, it's very practical, and it's actually one of a kind, or the first, or groundbreaking in this field, because there's not much literature about this type of law and the practice of law in these areas. So there's five chapters in this part by Pitt, Matengwa, Sake, Raselebe, Sapiri, and Green. I don't know who of those is in attendance. But to come back to your question, so this chapter you're referring to, let me just see, it's chapter 16, and it's evidence lost in translation and interpretation, a critical analysis of language implications during court trials. And it speaks about the sorry about my pronunciations, Sitjordana Msewa case, and it illustrates how evidence can be compromised when meaning is filtered through English-only court procedures, and it actually links quite well with what Zakira and Russell just said. Misinterpretations of words like Kolosi and Kral reveal how cultural nuance was lost. And that's actually exactly what Russell just said about it's not only the physical interpretation, but the cultural nuance is so important, and that is why you need judges and judiciary officers, and actually cultural leaders as interpreters as well in the courts, in that specific context where the courts are situated. So in shaping the judge's understanding of the eventual verdict, that was quite that is quite difficult if you don't shape the judge. If the judge doesn't know anything about the context, it's so difficult for him or her to shape the verdict. And the danger is that justice become inaccessible and unfair when court language diverges too far from lived cultural realities. If you see, this is so specialized, and witchcraft and the Witchcraft Act, it's a specialized field, and if you don't know anything about it, and you don't know the cultural nuance that is related to this, it's quite difficult to make a judgment. And reform could involve expanding indigenous languages as language of record, obviously, as we said, and we have said that many times before, professionalizing court interpreting and integrating cultural expertise into trials. I think that is quite important as expert witnesses, especially when it's trials that deals with cultural aspects, such as witchcraft and stuff like that. Yeah, the witchcraft, sorry, not such as witchcraft, the Witchcraft Suppression Act and other cultural practices.
So much. Tell me, do you think that there's a role for assessors to play here? We don't
I think so.
Yes, go ahead.
No, sorry, say. Yeah, well, welcome.
I think that, we don't obviously have assessors always in civil matters, but in criminal matters, there's the possibility for that. Is that something that can enhance or mitigate this problem in any way?
I, I think so. If it always depends obviously on the context of the trial, and if it's something that has to do with cultural aspects, and um, nobody in the courtroom has that expertise, you have to get in expertise. It's exactly the same with the
Yes.
expert witness. Why isn't that in why isn't expert witnesses brought in when cultural aspects are at play? I mean,
Yes.
nobody, if there's some speciality or that needs to be brought in another court case, say ballistic evidence or something, then you get somebody. Why not do it with cultural aspects? And that is what we're trying to do with forensic linguistics. It's only now that we've been getting into courts, and there's so many cases that we refer to where the main thing is language or was language, but no language expertise has been brought in. And I think it's the same thing with cultural expertise.
So, do you think that prosecutors, for example, need to be more alive to what you've just said and need to proactively go and find experts to come and testify in instances where a court doesn't have an assessor?
Yes, I think so, but I think it's a dual thing. So um, they need it's the community, the research community, such as us. We are a group of researchers, and we are advocates for forensic linguistics and language and the law and all the different components. And I think we should be more take a more activistic stance towards that and make ourselves available and publish on that, and do research on that. And I think that is a why we get people and officers and lawyers that comes to us and say, but listen here, we have this problem. We need your kind of expertise because we don't know how to deal with it. And I think so. It's a dual thing. Prosecutors should be more sensitized towards the expertise they need, but the expertise, the researchers, and the experts should also be more vocal about their expertise. And I think if you bring that together, then it's a win-win situation.
Thanks very much, Annalise. And on that note, perhaps I can ask you, Zakira, do you think that forensic and legal linguistics as a discipline is facing any kind of pushback from other linguists and applied linguists?
Yeah, it's a good question, Sanja. I mean, if we look at it globally, and I mean, the go-to immediately we think of Australia, we think of the UK because that's where you'll have forensic and legal linguists testifying in court most often and providing those expert opinions, you know. And then obviously we come to our context and the broader African context, and then it becomes a little bit more complicated, exactly what Annalise was saying, is that
Yes.
we haven't normalized, bringing in a forensic or a legal linguist. And I think, again, we see in the more popular cases recently that suddenly when there's media spotlight on the fact that there's a forensic or a legal linguist sitting there and giving evidence, it's quite a big thing. And, people make a joke about the fact that, okay, you're giving evidence about language. We all understand language. But I think, Sonia, this is also an issue with some of the judges. And I say some because I don't want to generalize. I mean, but when we look at specific judgments, I mean, judges commenting and interpreting evidence, which is specialized and requires a forensic or legal linguist there, and acting like, it's nothing and they can sort of do it. And the criticism, I think, from our side as academics and as practicing forensic and legal linguists is to say, why are you not calling us? And the response is to say, well, it's language, so we can all read that and we can understand it in a sense. But the technicalities, again, it goes back to, the interpretational issues in courts and the misinterpretation. And how are we using our languages where perhaps there's a cultural or there's a linguistic void and there's no equivalence between languages. Again, we see, not part of this book, obviously, but we see the outplaying of emojis and the interpretation of that. So I think there is a need for a forensic and legal linguist. It's becoming very evident, and there's a growing need. And based on the contributions in this book, I mean, if we look, for instance, and I'm going to pick out one specific chapter contribution by Precious Lungu, and, you know, he looks at the pushback that forensic and legal linguistic academics are receiving within universities. And it's a very honest account of what's happening within our institutions. And again, I'm generalizing very broadly. But, you know, from pure linguists to say, okay, well, what is forensic linguistics? What is legal linguistics? You know, don't you belong rather in the law faculty because your research is dealing with the law? And, or pure linguists saying, look, it belongs with us in the linguistics department, or it belongs, you know, in the African languages section because you're dealing with indigenous languages. So I think there's also this fight about ownership of a discipline. And we need to be very careful. We're trying to contribute to solving real life problems. That's our main goal. But I think if there's going to be pushback and inner fighting within the academic community, we're not going to get anywhere, because this is a collective effort, and I think we're all working towards the same goal. I think too, there's a misunderstanding of even how we're doing it tonight, interchangeably using this word forensic linguistics, and it's sort of our go-to rather than saying, okay, legal linguistics, which we know the book focuses on legal linguistics. But yeah, I think the distinction needs to be drawn. You know, legal linguistics doesn't mean you necessarily are based in a law faculty. It means that you have LLB competencies, even at a higher level perhaps, and linguistic background as well. Whereas your forensic linguists are more coming from your applied languages and your pure linguistic stream. So there is a slight difference. We see that again coming in globally. But to go back to your question, Sanja, on the pushback and to Precious's chapter, he actually documents where he conducts surveys within universities to say, what are your views on forensic linguistics? And a lot of the academics say, it should just be offered as a course. It's not really important. It shouldn't be a fully fledged degree. So again, you know, where we are in the current state on the African continent, and I'm taking nothing away from the research that we're producing, obviously, but we're so behind in the sense of, if we look at the UK and the fact that they have masters and honors programs fully fledged in forensic and legal linguistics, we again are just offering it as a course. And we are playing catch up, and I think that we've made great strides, but we need support. And I think, you know, to have people like Professor Motinyane and other deans and deputy deans in various faculties across our institutions is great, because people like that see it as a positive contribution to addressing linguistic issues facing our legal system. But yeah, a lot of pushback, and it's quite sad to see, and not just from within our institutions, just from the general public within South Africa as well. There's been a lot of negative commentary coming out, which has been disappointing, about what is a forensic and legal linguist and if we really need these people, which is sad.
Yes, I agree. It is sad, especially as we've seen the value you can add in proceedings. I think it's, as Annelies was saying, attorneys seem to be asking you to come out and assist, but it's not yet, as you say, common practice, and you need support to be able to get to that level where it is common practice. Annelies,
And I think
yes.
not just in court, and not just in courts, because if we look at the chapter contributions in this book, I mean, you know, Annelies and Corinne Brits contributed a chapter where they were actually expert witnesses in a case. And we often focus on, yes, the book focuses on courtroom discourse, but I think we also must define what we understand by courtroom discourse, because
Yes.
they were at an arbitration matter, in a sense, you know, where Russell was talking about that word police monarchy and the linguistic interpretation surrounding that. So again, at the tribunal, what I did, so it's various spaces, and I think this is where the forensic linguists are actually making their mark within South Africa, and perhaps other colleagues on the platform will comment on that too. But it seems to be, Sanja, that our contributions are coming in tribunal forums, at CCMA hearings, and within university disciplinary hearings and so forth. So I think if the courts can take a look at what we're actually doing in those spaces, then the work will become worthwhile and will get recognized. But I mean, it's not about recognizing the research that we're putting forward so much as to say we're trying to help people and we're trying to improve the justice system. I think a lot of judges think we're working against them because we offer critique, but the critique is there to assist, not to disadvantage anybody or insult anybody.
That's interesting that judges feel that. I find that very strange. Annelies, I wanted to ask you, what do you think are some of the broader social and economic consequences that arise when ordinary people who are trying to get access to justice can't access legal documents in their own language?
Thank you, Sanja. I will answer your question shortly. I just want to add something on what Zakira just said about
Please.
where language and the law and in which faculty it must be situated, or in which domain, academic domain. I think and she talked about applied linguistics, and applied linguistics in essential is solving real life problems that has to do with language, and that makes it so interdisciplinary and practical. And it's not only people with African language background or indigenous or a language background. You use, I think, in the chapter Karine and myself wrote, it was theoretical linguistics that helped us with that, and phonology, morphology, the way it was very theoretical, but also social linguistics, where we look at language within a culture. And then, as we also used computational linguistics, corpus linguistics. So it's so interdisciplinary. We see a lot of work that has been done with forensic linguistics and computational linguistics happen at the Aston University, and those people have the competency of technology and the integration of technology and language and the utilizing of technological tools and AI, as Russell just said, within these contexts. So it is not only either or, it's an and field, and I think we should embrace that, and that is why I love the contributing authors. If you look at them, they're from different fields, and I think that is what makes the field so interesting. And sorry, your actual question was on the broad social and economic consequences arise, and I think it has been said. But if you think from a practical point of view, when wills are drafted only in English or in Afrikaans, many South Africans, particularly those who speak indigenous languages as their first or only language, are excluded. And that is only a will is something that happens to everybody. It's not something, maybe I will end up in court or maybe not, but a will and all those legal documentation you receive and you have to work through every day. If you are not able to understand that language, it is so difficult, and you are being discriminated against, and you are excluded from fully understanding or executing these documents. A contract, think of a cell phone contract. You don't know if you don't know it's legalese, and if it's not even in your language, I mean, it's difficult for a person with high competency in English to know what they are signing up for. imagine it's a third or fourth, fifth language. This exclusion not only breeds mistrusts and disputes within families, if we look at a will point of view, and we see that every day within families, but also undermines access to justice and fair distribution of property. And we see that there's some case studies that we see in part 4 that touched on that. And the chapters in part 4 argues that translating wills into indigenous languages could promote fairness, reduce conflict, and strengthen legal literacy in communities.
Fantastic. I think we need to do so much work there. If I think about all of the legal documents or legal adjacent documents that you come into contact with, just as a person in your day-to-day life,
Exactly.
and how it must be absolutely impossible for most people to understand what they're reading in South Africa because their language is simply not accommodated.
Exactly, and
Russell,
they are hold to that terms,
yes,
and they don't know what
yes.
they're right. They want the cell phone or the whatever, the lease or whatever.
Yes, I mean, don't even get me started on sort of the medico-legal context where people need to consent to things and, who knows what a bilateral tubal ligation is? Nobody knows what that is. And even things like advanced directives and, communicating your wishes to a doctor,
Yeah.
to a healthcare worker. I think that's a very tricky area in the law that needs some sorting out. Russell, tell me about in the perfect world, in your perfect world, how do you think forensic and legal linguistics can play a role in the multilingual and multicultural courtrooms here in South Africa, where the language of record does still remain English? And maybe you can sneak in a little bit about your thinking around AI in there, if it's possible.
Okay, in the ideal world, let's start with universities themselves because I think before we even get to forensic linguistics in the ideal world, we need to look at the university system, and I'm just thinking about this recent discussion now on the ownership of disciplines, because I would follow a different approach where we don't have departments or faculties in universities, where we just have subjects. And I think that's how universities started, and this whole thing has been hijacked because now it's become like a territory kind of thing, and
Silos,
you
yes.
know, and all of the pushback that colleagues have spoken about is related to that. And I think if you were going to be a university student and you could choose 10 subjects and get a degree, that would be much healthier than having to do 10 subjects in a specific faculty from specific departments. And you wouldn't have all this infighting, and you'd have a much broader based student who comes out with a knowledge discipline that would fit what their interests are and what society needs, hopefully. So that would be an ideal situation from where a forensic linguist could spring, I think. And it would also mean, let's put it this way, if you are multilingual, and you have an understanding of forensic linguistics or legal linguistics, and you are applying to be a judge, I do think it should be considered as part of your appointment, and that multilingual citizens should get preference over monolingual citizens, because that would reduce and remove the race card that often comes into it, because you are not being promoted on the basis of race or anything like that. It's it's on different societal values that we now acknowledge as important, and language being one of them in the legal fraternity, or in fact in any discipline in Africa. So I think we could use language in a much more creative way, following the Neville Alexander kind of approach, where you use persons' multiculturalism and multilingualism aspects to look at their value in society and what role they can play, rather than fixating on a person's race. So yeah, that's one thing I think could be important. And I think we can use, in an ideal world, legal linguists and forensic linguists in the court system as assessors. That has already been noted. But then I still think it's not going to have much of an impact, because the people on the bench or the judge do not have to necessarily take into account the assessor's point of view. They can discredit the assessor. So I think there should be mechanisms in place to actually force them to engage with what the assessor stroke forensic linguist is saying or suggesting in a particular court case, and that whole thing should also form part of our training, if you like. And it doesn't help to start thinking about forensic linguists as part of a jurist system, or a juror system like they have in America, because even there you have all sorts of linguistic and cultural prejudices that come to the fore. So, because the average person who forms part of the jury has not been trained either necessarily. So I think there's no ideal world when it comes to the role forensic linguists are going to play, Sanya. But I do think at the core of it is rethinking our entire educational system so that we produce people who are more balanced and less territorial in the way that they see the world. And I'm not going to go into recent experiences at UWC regarding the field of forensic linguistics, but I do think it's both a top-down and bottom-up kind of impetus that one needs in terms of top management and people on the ground who then buy into it as well, in order to move the discipline along so that it can become groundbreaking and that it can form part of a more ideal situation within the legal fraternity and the, let's call it, language fraternity rather than linguistic fraternity. And there's always going to be pushback, because humans are by nature, I think, quite territorial. You know, don't anyway, humans are by nature sort of territorial, but and we need to look at it from that point of view. So when people feel threatened, and there's economics involved as well, you know, if you want to set up a center for forensic linguistics, it means you've got to employ people. It means that somebody else might think that you're going to take away their researcher from their center. So I just think the debate should be broader as to what it is that we need as humanity, and how that dovetails with language and society, and and the need for a civil society that is responsive to issues around language and culture. And I don't think all of these disciplines actually help us at all. So I'd like that to be the point of departure in a debate. If colleagues from Mzuzu are here, maybe in Malawi, they could also contribute, because they've got, I recently read a very good master's thesis on police interviewing from that university, and they have established a more concrete master's program there, sort of that follows along with what maybe Aston and them are doing. But I don't know. So it's difficult to say that we can have an ideal world where forensic linguists will operate with the pushback that we see. But I think we carry on and we do what we can on our own, you know, on our own corner. And I think I must just say as well, I think Zakira has done an enormous amount to position us as forensic linguists out there in the public, which is very important as well. And all of us, obviously, all of us even here together, we are all working in our own way to make sure that language becomes the center of legal debates and not the periphery of these debates. But that would be my sort of general comment, Sanja. Thank you.
Thanks, Russell. I think, I mean, I'm one of those people whose eyes have been opened to legal and forensic linguistics, and the real value that it can add to proceedings. And in hindsight, it seems so obvious. It seems so obvious that that there's a benefit and that there's a need, especially in a country where we have so many languages and we have a multicultural, multilingual environment in all of our legal settings. So thanks very much. I would like to now open the floor for questions. You can pose your question in the chat or you can raise your hand. Please do introduce yourself and tell us where you're coming from. And when you ask your question, you're welcome to address it to a particular panelist, or you can just ask your question and we'll see who wants to take it. The floor is yours, guests. Don't be shy. Get the ball rolling. No hands? No questions for panelists? Professor Martignani.
Thank you very much. I think I'm going to be the devil's advocate here. The focus is on, in a way, foregrounding indigenous African languages. But much of the work that's happening is continuing the Western lens, because we are looking at African languages, their use, but we are reporting all this information in English. Are we at some point going to be doing this in indigenous African languages? And this is not to a specific person, it's an open question. Thank you, Chair.
Thank you, Prof. Any of our panelists feel like they would like to venture an answer there?
I think what is exciting, if I may, Sanja, is that certain journals are now accepting articles written in African languages. And I know, I recently read an article, I think it was also on the ILAF, where Dr. Bagetwana wrote about the intellectualization of African languages, and he wrote the article in isiXhosa as well, and that it was a misnomer to speak about the intellectualization. He should rather be speaking about the re-intellectualization of African languages because they've always been intellectualized. And he made some really good points. And I think it's up to us or people who are mother tongue speakers to actually, contribute to the debate that Prof. Motinyane has raised by taking ownership over that space. Because if we don't do it as African language speakers, then, no one else is going to do it, because those who speak English and so on are already privileged and have all the rights and don't want to lose those rights necessarily and have no interest really in promoting African languages. And we see this in all or most of the policies as well that are issued or created in this country. It ends up being sort of like leaning towards English as medium of instruction, or English as, the language of record, or, so I think I'm very excited by what Dr. Plegetwana has done. And there's also a book that's been published. In fact, there's two books. I think Prof. Motinyane might be an author in one of the books, So, she's already taken ownership over that space. And I know that Prof. Hlongwa also wrote a textbook for sociolinguistics and language planning in isiZulu. So it's those, I think it's just not something that's going to happen overnight, but I'm not feeling too, sort of like concerned that it will never happen, because it sort of is happening in little pockets. But maybe at a Pansal or governmental level, it needs to be coordinated in a better way. And even the mother tongue, if you think about the mother tongue debate, we just published an article in the Daily Maverick, I think it was yesterday, where an open letter to the minister, who had accepted that mother tongue based bilingual education would start in 2025 across the country. But when you look at the funding aspects, it's not a funded part of her projects. So how's it going to happen? So there's a lot of talk around, constitutionally empowering people in terms of their languages, but there's very little action. So when I see books like that, I'm not sure if I'm answering the question or not, but I find it exciting anyway when I see a new kind of thinking emerging, a sort of a Ngugi type thinking, if you like, or Biko type thinking around the question of language. So I don't know. Thank you.
Russell, Annelies, what do you think?
Yes, I've been thinking about ways we can work with it from a practical. I'm a very practical person from a practical point of view. And I think in South Africa, with our lingua franca is English, but with our different language communities, we should be starting to think about translation of court rulings. And that is something that should, I think, we can't be dependent on the state to do something like that, because they won't do it. But NGOs and researchers and research groups can actually start thinking about the translation of, because then terminology, and especially when the parties are not well versed in English, then you translate in, say, Sepedi, or whatever the case may be, when if that is the languages of the parties, and if there's different language communities involved, then just uh, then do it for the losing side, so that they can understand the implications. Or but I think in that way we can ensure that it that although it's not on the official record, if the state or the government or other structures doesn't want to work with us on that, then we can do it from the NGO or academic side. And then there's a record. And then what happens if you translate something, then you terminology starts to arise. So, and then textbooks can be written in different languages. So translation is actually the key if you want to do it from a language community point of view. And I think that is one option we should be looking at, especially with our students. We can ask students to do it as part of their research, or and there's the translation students, or the students in theoretical linguistics can help with that, and obviously it can be a collab. So translation is something we should take seriously.
I can so agree with that. I think that sounds fantastic. Sakira, what do you think?
I want to build on what Annalisa said. I mean, if we're going to say we're translating judgments, which is a fantastic idea, I'm also just looking at Karen Britz's question about resources and so. But before I comment on that, I mean, what about the fact of using bilingual judgment writing, Sonia? Because that has been coming out in little pockets, and I'm just thinking about what the Chief Justice has done way before she even became the Chief Justice, and writing bilingually. And she was not the first person to do that. I mean, you'll know that Justice Froneman also did that with English and Afrikaans. And similar to adopting the Western approach that Prof. Mortignane so rightfully talks about, but that bilingual approach that Canada and Belgium have, and we trying to do that using the African languages, and I think it works really well because then you're still maintaining that monolingual language of record policy that's so problematic. But at the same time, you're contributing to the development of the languages, and then the judgment becomes available in the indigenous language. So, both sides win. But again, it's about empowering the judges, I think, and creating a safe space within the judiciary. And I specifically say a safe space because the policy and practices within the judiciary have become quite tense, where we see certain judges taking the side of that English only policy and others promoting the multilingual approach. But I think we're slowly starting to see perhaps a shift in that thinking, Sanja, where it's just about writing in English and delivering a judgment in English and so forth. But with the Chief Justice coming in now and pushing that multilingual agenda, I think we should be watching the space to say we're going to be seeing more judges writing bilingually. And we know from past experiences that magistrates in the lower courts were writing judgments in the indigenous languages. And we have this issue when it goes on review and appeal, okay, who's going to translate it? But then exactly Annalisa's point comes there in, because you get an NGO or you get an academic, as you say, who's running a project and it's research funded with students translating. So again, I think it also talks to the partnership that is being created within the judiciary with the academic voice too. And I think it's going to be an interesting space to watch in the next couple of years.
Fabulous. We have a question from Karin Brits, who says there is a misinterpretation that the multilingual approach is expensive and difficult. How does one address that? How do we disabuse people of that notion? Any panelists want to grab that one?
I'll start if that's okay.
Thanks, Akira. Yes, please.
Annalise and Russell add. But I think the most basic thing is to use provincial language policies. And if we go with that approach, we'd be using like a bilingual approach, which we've advocated for a very long time, to say there are majority spoken languages in each province. So I think the whole issue of having one policy for the entire country doesn't work because we're so multilingual. And perhaps that's the problem. We're overthinking it, and we're trying to use one policy to fix a broken system, as it may be. So, I mean, the Eastern Cape, Western Cape, and so forth, those are easy in a sense where we have 2 or 3 dominant languages. But again, where we get to provinces like Gauteng, and then we're dealing with multiple languages. And I have a student now who's looking at Gauteng and the languages that are being used within the Pretoria and the Joburg High Courts. And I mean, it's about 6 and 7 language perhaps in one trial, which is crazy.
Wow.
But those are the realities that are coming out. But again, I think there's an approach of how we do this. And I'm also thinking about the research and perhaps the insights of Cornelius Lawrence, who wrote the foreword to this book. And he's long advocated to say within Gauteng that, again, there are dominant languages and you need to break it down according to jurisdiction and the geographical area. And he looks obviously specifically at the lower courts. So there'll be dominant languages in those little pockets as well that we can look at. And we might then end up with multiple policies within one province where it is so multilingual. And I don't think that's a bad thing, especially when you're enhancing access to justice. That would be my 2 cents.
Thank you very much. Annalise, Russell, anything to add?
I just think the one size fits all kind of policy making doesn't work in South Africa, and that the constitution is fundamentally flawed because it recognizes 12 official languages, which are not even which are varieties. So it shouldn't even mention the varieties of language. We should have recognized all varieties as official because it's a policy. It's a very broad statement document the Constitution. And that would have allowed us to implement what Sakira is now suggesting, which would be a localized, much more localized approach to language policy making and implementation. And in a sense, that would be the key to unlocking the potential of our languages with financial backing from government departments. And Kathleen Juch has done some research on that and came up with a figure of 2% for each department to implement multilingual language policies. And I like the idea of what Justice Maya is doing as well, because, it basically, you are growing the jurisprudence within a particular language when you do that. And
Yes.
it may be also that we don't have to translate or produce entire judgments in both languages, but aspects of a judgment. Like, we're thinking, for example, a thesis, like the abstract of the thesis could be in various languages, and the thesis could be written in English, and there could be summaries of the chapters in an African language at the end. We could do the same kind of thinking around judgments. And it would really be up to judges individually, I guess, unless policies were put in place. But what Justice Maya is doing, I think, is a very, very good example of what can be done. And it's not reinventing the wheel because, when Afrikaans and English were the official languages, that was, as I understand, the process that was often followed anyway. So it's about looking at what a particular court in a particular area needs and who are the speakers in that area and going from there rather than saying we have 12 official languages. I think that that's a fundamentally flawed point of departure. And I've been thinking about that for about a year or two now. And the more that I think about it, I think we need to go back to the Constitution because there's something. You have, for example, Kelobedu or Isimpondo or Isibhaca speakers or Hlubi speakers saying, but I feel like I'm not recognized in the legal system. I'm not even recognized in the Constitution. So. And isiXhosa and isiZulu and isiNdebele and Siswati anyway are sister languages and mutually intelligible, as are some of the other Sotho varieties as well. So I think the whole thing needs to be rethought as to what is an official language and how do we implement language planning and policy in a practical way in given contexts. And the banking system has done that. Absa Bank knows in what suburb, like what speakers live in that suburb, and then the auto bank gives the languages that are used in that suburb. So if they can do it, why can't anybody else do it?
Great point. Annelies, what do you think?
I see. I will keep it very short. We must keep in mind that the Use of Official Language Act already the structures are in place, and Pansat is mandated to follow through with that act, and all the different departments, not only in a legal context, should adhere to those. The things that's in that act and the localized language point of it, the three language in a certain area or certain province. So everything is there. We don't have to reinvent the wheel. It just must be implemented, and that is where we are stuck.
Absolutely. Sounds familiar. Implementation. We've got Alfred Chuma, who has asked, where do you see the future of forensic linguistics going in Africa? Do we see that forensic linguists will have serious access to the courtroom and do the job that can be appreciated by the judges? Or are the judges going to keep on living in denial?
I think in the South African context, forensic and legal linguists are going to be used more. We're seeing that coming through. I think it's inevitable because of the challenges that are arising. Again, I do think it's based on the leadership of the judiciary, and I bring it back to the Chief Justice. So I think as soon as you have a judiciary and a leader who recognizes the significance of languages other than English, then you'll immediately see the growth of the discipline from a point of practicality and using it in courts. And South Africa has always been a leader on the African continent in a sense. I do think that we can learn from other African countries, but when we look at the research that's coming through, even in this book, Sanja, from contributors across the continent, I mean, the growth of forensic linguistics and, its impact within the courtroom has just been immense. So I do think it's going to go from strength to strength, and forensic and legal linguists will continuously be used.
I think you might be right. Annelies, Russell, would you like to add anything?
No, I think that's a good note on which to end because I think it summarizes us in a very positive way, which is great. And yeah, if we look at what to go back to the question, I mean, what has happened in the last 5 years in South Africa has been, to answer Alfred's question, quite phenomenal in terms of how forensic linguistics has grown. And, we can benchmark against Australia and the UK and the USA and so on, but, we are moving continentally. And I think between Mzuzu and Moi and UWC and, the American University in Cairo and various other universities and the African Association of Forensic Linguists, which we are trying to get off the ground, of which Annelies is also on the board, we need to come together and just keep going. I think we're on the right track. And to produce more students who can become professional forensic linguists. I have a master's student, for example, who was just appointed in the Blue Downs Magistrates Court as a language facilitator, So it's not an event, I don't think. I think it's a process. But if we do have support from our chief justices and so on, I think we can go far. And we just need to keep going and build bridges and collaborations and produce the kinds of books like this that show the value of forensic linguistics and keep going forward, I would say.
Excellent.
Yeah.
Sounds like you need to organize and mobilize. We have a question from Francis Dyers. If many of the policymakers are not listening to the professionals in their research, especially when it comes to things like the language of record or translator training, then what other actions can there be? Organized protest, petitions, up around universities, or initiatives to educate the public who may think these things are not important? What do you think? What might be feasible?
Sanja, if I can come in, there was an
Please do.
excellent article in, I think it was 1990, and I think that article was way ahead of its time. The author actually, in a thoughts, Martel, I can't remember the first name, and Professor Theo du Plessis wrote quite extensively on that, and that is on language activism. And language activism takes many forms, which one of it is lobbying, media, research, making use of the legal framework or the legal system. Obviously, it is as Francis Dyer said. There's other ways as well, like protesting and stuff like that. But there's a whole field of study on language activism, and I think we should take on the last resort is violence, which we don't want to go to, but that is also a form, and we see that in South Africa's history, violence was a part of language activism. So I think we should touch on all those different aspects of language activism in a well-organized, well-researched way. And if the media, it's such a good a driving force getting your ideas across. And if your ideas can be is well founded in research, then it obviously speak for itself. So yeah, I
Yes.
think we should take the stance of language activism in its different forms and make use of the different drivers which is available.
Thanks, Annalise. I really like the idea of language activism. Anything to add, Zakira?
I'm just thinking also about PanSolve, and I think Annalise already mentioned PanSolve as a structure, but they've got this linguistic rights section. I don't know if I'm getting the name right, but that they've set up as part of PanSolve that addresses these very issues. So, for instance, like just basic complaints regarding language or access to justice, or you know. Where there's been a lack of interpretation or there's been a delay to your trial, and you can go and log the complaint with PanSolve. And before, in the past, we know that that never happened. Nobody ever followed up on it. So now they've actually got a dedicated section dealing with these complaints and driving it forward. So almost like an activist branch of PanSolve in a sense. Look, they I think they're somewhat guarded still, and I know this is being recorded, but I think I can speak openly and honestly. So it's going to be interesting to see if anything comes from the complaints that people are laying, with the body, and whether they are going to be holding government accountable and other organs of state and so forth. But yeah, again, I wouldn't go and stage a protest. I'm not encouraging anybody to stage a protest. But I think it's about, like Annalise said, using the specific platforms and especially the media, because we know how powerful the media can be. So I think, if you're penning your pieces within the media or you're chatting to journalists and so forth and getting the stories out, I think that's a really important, cog in the process.
Thanks very much. We have a final question, and how fitting. It's Prof. Motinyane who started us off and is now posing the final question. Given that there are case studies from other countries, Malawi, Cameroon, for example, what lessons can South Africa learn?
That English doesn't work. That's the no, it's true.
Yeah.
It's the bottom line. I mean, we need to use an international language, and we recognize that, but we're not using it equally. And I think people misunderstand when we say we want to use the indigenous languages. They immediately think that we want to get rid of English, or we want to get rid of French, depending on which part of the world you're in. That's not what we're advocating for. We're advocating for placing all the languages equally alongside each other, or finding spaces in which we can use the languages equally. So to look at the African case studies and the models that are coming out there, I think it's more lessons of what we should be avoiding, Sanja, rather than what is being done right, and that might not be a bad thing, in a sense. But yeah, again, I think it's a partnership of, because it's new on the African continent, looking and talking with these colleagues and just reading this book and engaging with the context coming especially out of Malawi and Cameroon, and what's coming out of there, and saying, look, let's learn, let's partner, because we have to try it and we have to start somewhere. I think that too is perhaps our problem, is we put a policy in place, and when that policy fails, then we just throw our hands up and say, okay, we tried, that's the end of it, we're just going to resort back to using English only. So I think it's about learning from each other. There might not be a lot at the moment, but that too will come.
Thank you. Russell, any thoughts?
I think reskilling is something we can learn. If I look at Malawi, the kind of way they're reskilling the police force through for studies in forensic linguistics and degreeing them at a master's level is something that we haven't been able to do on a large scale in South Africa. And I think Zakira's right. I mean, it is showing that English, French, and Portuguese are not the only languages that are used, in courtrooms in Africa, or should not be the only languages used. And it will be interesting to watch Burkina Faso, who have made Bambara their official language, and to see how that plays out in courtrooms in Burkina Faso over the next 5 or 10 years. So I would encourage us to watch that space, because they've removed French altogether. So there are different things happening in different parts of Africa, which I think we can learn from. And yes, I think we can all be language activists, as Annelies was saying, in various ways. And maybe that speaks also to Francis's question, because we can all do what we can in terms of media intervention and conscientizing people around us, even within our own spaces, which is kind of what we've been doing, with some degree of success sometimes, over the last 20 or 30 years. And I think we need to go back to Prof. Motinyane's question, to do a lot more comparative work in forensic linguistics between what's happening in different countries, and we can intellectualize that debate in the form of master's and PhD theses. And I think Zakira's PhD showed us to some extent how you can do that. And Francis's work on comparing Japan, gender-based violence and rape in Japan and South Africa at the honors level that she did it at, was to me most fascinating. So I think we can do a lot more comparative work in the space that we're in. Yeah. But thank you very much for the opportunity, and to share all these ideas was great fun. Thanks.
Thank you. Annelies.
Yeah, I will commence with this last comment. If we attend, and it's not to blow our own whistle, or our own trumpet, but if we attend the international conferences, and most of the delegates are from European countries, or countries which spend more, or does not have the language.
Have we lost Annelies? Oh, there she is.
Needs answers and needs creative solutions.
Oh dear, I think Annelies's internet has had enough for today, but I'm sure she'll come back in a second. While we wait for her, can I give panelists an opportunity for some final comments, final thoughts before we wrap up? Akira, after you.
Thanks to everybody, first of all, who joined and participated, and thank you to you, Sanja, for facilitating it. It's been fantastic, and yeah, Russell said it's been fun. It really has been. I think for me, the biggest takeaway from this book is the practical element. I think for the very first time as well, we've got legal practitioners, court intermediaries, people within the system contributing their research. And if I'm correct, this is the first publication that has actually documented the work of court intermediaries and the research that is coming out of the court system. So in that sense, it's groundbreaking. I think it also gives a lot of meaning to the work that's being done on the African continent. For a very long time, should I say, we've had the European scholars writing about what's happening here in our system. And I think this book has allowed us to put forward what is actually happening from our perspective, and to clarify certain things. And I think it's made a major contribution to how we can proceed by using languages other than English, which for me is the biggest takeaway. That would be my final word.
Thank you so much. I think it's crazy that this is the first time that we're talking about the experiences of intermediaries. I mean, that really is groundbreaking. Thank you. Annalise, I see you are back. Please, you're welcome to finish your thought. Sorry, your internet betrayed you there for a second.
Yes,
And
sorry.
then you're also welcome to give us some final comments
Okay.
for the evening before we say goodbye.
No, I just want to, this will be my final comment. As I was saying, we are actually in a very good position regarding research on the African continent. If we look at the problems the Europeans now face with the globalization and different language communities coming into different countries, and now it's the first time they experience the problems we've been dealing with for a long time now, and they are at the point of, oh, this is the problem, and we are at the point of solutions. So I think we always feel I don't want to say good, because it's still a long way to go, but we're feeling we're making a difference here in Africa, and it's something we can share with the world, and I think that's good to work with colleagues in different countries.
Thank you so much. What a lovely positive note to end on. Russell.
Well, also just to thank colleagues and thank my co-editors in the book as well. And I think it's exciting that we can produce these books, and I think we're on a good footing, and looking forward to producing more books. And I think more comparative work needs to be done. And just from our own point of view, to say that we have had the African Center for Applied Research in Forensic Linguistics approved at our university, pending funding issues. But in principle, it's been approved. So that's a great stride forwards for UWC and for all of us as colleagues who are working in the field. Hopefully, we can all benefit from that center when it becomes operational. And that we've also put in for a chair in Tier 1 chair with the National Research Foundation for Forensic Linguistics. So we are positive that that might happen this year, which would also help us to establish the field in Southern Africa. And just lastly, we hosted the International Association of Forensic and Legal Linguists Conference in June and July. And many of us were at that conference, and I was really warmed by the way in which the international scholars, I could feel the way in which they viewed our research and viewed us as scholars was in a very positive way, and they were really open to also learn from us. And not just us learning from the West, but them learning from us from the South. So that to me was very warming. So I think if we can build collaborations and move the discipline forward, there'll be many more books and many more exciting things to come. And I agree with Annalise that we are on a good footing, and we need to constantly be language activists, but in a way that is positive and building and not negative. So that would be my final comment. Thank you,
Thank you so
Sanja.
much, Russell.
Thank you also for sharing.
Oh, you're so welcome. I had the privilege of attending the conference that you just referred to, and I certainly learned a lot. And I cross fingers and toes that you get your research chair. I think it might be in the bag. Folks, our time together has come to an end for tonight. Thanks again to each of every one of you for making time to join us for the launch of Courtroom Discourse. To our panelists and our contributing authors, and to the Indigenous Languages Action Forum for hosting this launch of this important publication. Thank you very much. You can order a copy of Courtroom Discourse for yourself or for your organization by sending an email to orders@africansunmedia.co.za. I will put that information in the chat for you. And thank you very much, and have a wonderful evening, and goodbye.
Thank you, everybody. Bye.
Thank you.
Bye.
Bye. Thank you.
Fantastic.